Hi, and welcome to Norton Rose Fulbright's Texas Business Court Insider. I'm Kate Ergenbright, and I'm here today with my colleague Rachel Roosth. This is the second video in the Texas Business Court Insider series analyzing what the Texas Business Court has accomplished in its first year in operation. Today, we're going to provide an overview of the types of opinions the Texas Business Court has issued in its first year. As a reminder, Texas Rule of Civil Procedure 360 requires the Texas Business Court judges to issue written opinions in certain situations. One is in connection with a dispositive ruling when a party requests a written opinion, and the other is when the issue is of importance to Texas jurisprudence, even if not requested by a party. In addition to that, the Texas Business Court judges have the discretion to issue written opinions in connection with any order as they see fit. Consistent with these rules, the Texas Business Court has issued 42 written opinions in its first year. Kate, can you tell us a little bit about these opinions?
Absolutely, Rachel. While 29 of the 42 written opinions the Texas Business Court has issued in its first year relate to the Texas Business Court analyzing its own jurisdiction, there are a number of cases that have broader application, providing litigants in Texas with trial court guidance on important and practical issues for which there is little Texas case law, at least at the trial court level. So in addition to those 29 business court jurisdiction cases, the court has also issued 4 opinions on other jurisdictional issues, such as challenges to personal jurisdiction through a special appearance. The court has issued 3 opinions on motions for summary judgment, 2 opinions resolving 91A motions to dismiss, 2 opinions on discovery-related issues, which we're going to get back to in a moment, 1 opinion resolving a motion to transfer venue, and another opinion resolving a motion to reconsider previously granted temporary injunctive relief.
So, Kate, let's pick back up on those 2 discovery orders. Typically, in a Texas state trial court, we're not going to receive a written opinion related to a discovery issue. The court will just tell us that the motion is granted or denied, and we don't get that written analysis. But thanks to the Texas Business Court, we're now starting to get written opinions on discovery issues. And in particular, we now have an opinion on the attorney's eyes only designation, which is typically used in protective orders. That opinion is from the Westlake v. Eastman Chemical case. In that case, the parties could not agree on whether there should be an attorney's eyes only designation as opposed to just a confidentiality designation in the protective order. And they also did not agree on whether, if there was an attorney's eyes only designation, whether it should apply to in-house counsel or not. So Eastman Chemical brought that issue to the Texas Business Court, and the Business Court determined that in that case, an AEO designation was appropriate to have in the protective order. Eastman Chemical was trying to protect customer and sales information, and there was risk that this information could be shared in discovery with a competitor because Westlake had affiliated entities that competed with Eastman Chemical, and those entities shared the same legal department. So the Texas Business Court decided it was appropriate to require an attorney's eyes only designation in the protective order and also to exclude the in-house counsel from that designation so that in-house attorneys at Westlake would not be able to see information that was protected by the AEO designation. As to the court's decision to exclude in-house counsel from access, the court said that it had to balance competing interests. It had to balance the risk of inadvertent disclosure or using that information for competitive decision-making against the requesting party's need for in-house counsel to have access to that information. So whether in-house counsel should be allowed to see AEO materials under a protective order is going to depend on the particular facts of a case, and if it's presented to the court, how the court balances those competing interests. The court also addressed the standard and burden shifting applicable when assessing whether an AEO designation appropriately applied to information. The party designating information as AEO would have to put forward evidence that the information is a trade secret or other confidential research, development, or commercial information, and that there's risk the designating party would suffer harm if the information were disclosed to the requesting party. If the designating party met that initial burden, then the burden would shift to the requesting party, who would then have to demonstrate why the requesting party needs the information to prosecute or defend the suit, and why it would be insufficient for only attorneys to have access to that information per the AEO designation. The requesting party would have to show that the AEO designation would actually prejudice that party's presentation of its case, and not just that the AEO designation would make the litigation process more difficult. So that's the Westlake v. Eastman Chemical opinion. Kate, can you tell us about the other discovery opinion from the Texas Business Court?
The other opinion was issued in the Safe Lease Insurance Service LLC versus Storable Inc. et al. Case. This opinion is a 38-page opinion that resolved a motion to reconsider a previously granted discovery order in which the Third Division ordered the production of the defendant Storable's customer list. This opinion specifically addressed whether Storable had preserved an argument that its customer list was protected by a trade secret privilege, and if that privilege had been preserved, whether the privilege would actually bar production of Storable's customer list. The court held that the answer to both of those questions was no. Now, with respect to preservation, the court held that Storable had not established it had sufficiently asserted a trade secret privilege for its customer list before the court had previously entered an order compelling production of that information. The court then went through a detailed explanation of how the privilege should have been raised under Texas Rule of Civil Procedure 193.3a and when that privilege should have been raised to preserve an argument the privilege applied. The court also held that even if that privilege was preserved, production of Storable's customer list would still be appropriate in this case, given the importance of that information to the plaintiff's antitrust claim, and given the protections that the court had already provided in a protective order that governed discovery in that case. Now, as the Texas Business Court continues to operate, I think litigants can expect to get more and more opinions like these two that we've discussed today on discovery-related and other practical issues involved in the day-to-day litigating of commercial disputes in Texas.
Thank you, Kate, and thank you all for joining us for this video. Please don't forget to like and subscribe if you want to be notified of future videos. There's also a link to the Texas Business Court Insider Hub down below. And on that hub, you can find additional materials. You'll find videos and written materials that expand on the issues that we've been discussing.